There is also the question of contributory negligence to be taken into account. The law does accept that sometimes the victim, the one who's suffering loss, may have actually brought upon themselves some of that loss. And if it comes round to a court case in the end, then it's possible for the court to award some of the damages against the victim themselves, in other words, lessening the liability of the institution. In reality, with the duty of care, very few cases are judged in court. In general, it's a decision about settlement, about deciding on the likelihood of winning that determines an amount of money that's paid to settle the case, rather than going through an entire court proceedings. In order to deal with any incidents, you should also consider what reasonable steps would be taken at that point. It's not just about avoiding the incidents happening, it's also about your response. A reasonable person would take action upon hearing about an incident. Further information that might help you there is available again from the Janet website, www.ja.net, and their paper on effective incident response guidance notes. Of course, key to dealing with the duty of care is being able to assess risk. And so risk assessment must be flagged up at appropriate points. Now, we're not talking here about forming a 12-person committee in order to judge risk, at least not in every circumstance. The risk assessment must be appropriate and proportionate to the activity that's being carried out. However, in many cases, it's simply been a case of someone not thinking of the possibilities of risk. And therefore, in lots of instances, an extra head thinking about what could come about is useful. So, to sum up duty of care, in each area, the question is whether there's foreseeable harm and what a reasonable person would do about it. And in order to avoid liability, you must carry out those actions. If someone does incur harm or loss and you haven't carried out those precautions, the institution may be liable. Moving on to the next area, sexual offences and obscene publications. The Sexual Offences Act of 2003, which applies in England, Wales and Northern Ireland, and there is equivalent provisions in Scotland, created an offence of meeting a child following sexual grooming. And here a child means someone under 16. It's now a crime for an individual to befriend a child on the internet or by other means, and to meet or intend to meet the child with the intention of abusing them. And the maximum sentence is 10 years imprisonment, reflecting the seriousness of the crime. Any knowledge by an institution of such activity must be reported to the police straight away. The Obscene Publications Acts make it illegal to publish material that tends to deprave and corrupt those viewing it. If the activities being depicted, which are at the root of obscenity, which the meaning of obscenity will depend on the activities being depicted. Only if an institution's senior officer is aware and knowingly permits the publishing or the distribution of such publications will they be liable and indeed possibly guilty of a criminal offence. The Sexual Offences Act 2003 makes it an offence for possession or publication of indecent images of children less than 18 years of age. In all of these situations, we're talking about criminal offences, and so an institution's duty is going to be to get onto the police and inform the police straight away and take advice and guidance and the lead from them. Beyond this, there is also, going back, the institution's duty of care. If students, particularly young students or pupils coming into a college from a school, are likely to be harmed by viewing certain images online, then the institution has a duty of care to take reasonable precautions to ensure that harm doesn't occur. There may be a number of technical measures which are available to avoid this. There's the question of educating the users as well, and there's the question of supervision as well. There isn't, unfortunately, a black and white guide to what is right in every circumstance. Each circumstance must be taken on its own merits and a judgment made as to what is appropriate for that age of learner and also the circumstances of the activity. Turning to defamation. The Defamation Act 1996 covers publication of an untrue statement which affects, it harms the reputation of an individual, and covers the author and the publisher of such a statement. There is a defence to persons who aren't authors, editors or commercial publishers in that they took reasonable care in relation to the publication of the statements and did not know and had no reason to believe that they published or contributed to the publication of a defamatory statement. This means if you merely set up Web 2 technology and leave it at arm's length without dealing with it, if someone posts something defamatory, then your institution will not be liable until it has notice of such a statement. And that notice might become because you're editing the discussion board, controlling it, moderating it, or it can come about through notice from another user. At that point where you have notice, then you must act because the defence disappears at that point. The High Court has held that an internet service provider which transmits a post to subscribers of a discussion list is not the publisher of the posting. However, the court also held that because the ISP had not removed the offending material as soon as it was notified, that it had not acted reasonably, and therefore the defence under the Defamation Act fell. And so, for example, the High Court awarded £10,000 in damages recently and over £7,000 in costs against a college lecturer who was found to have committed libel through her postings to an internet message board. In some circumstances, because of personal reasons, the action might be taken against the individual, in this case a college lecturer, rather than the institution, to prove a point in many ways. However, it is possible for the institution to be liable as well as the publisher of a defamatory statement. Computer misuse. It's another area. Users could be affected by unauthorised use of the computer facilities. The Computer Misuse Act 1990 deals with this, making it a criminal offence to hack into computer systems, put very briefly. However, there is also a duty of care upon the institution. So, for example, if an institution is asking students to engage in e-assessment, then it must make sure that they are safe from interference with their answers that they are submitting and the process.